So nature and classification of companies. Nature and classification of companies. We're going to finalize on this topic. We are going to close on this topic, nature and classification. Nature and classification of companies. So because I've already been able to share the notes, you have them. So don't focus on writing a lot what I'll be writing here on the board. What I'll basically be discussing is what is already in the notes I've already been able to share. So don't start having to tell me you are writing, I waited, because I'll move a bit faster. I'll move a bit faster because you already have the notes. So the best thing you can be able to do, you print those notes, you'll be having them. So just print them and be having them. So don't waste a lot of time writing a lot about what I'll be indicating on the board, because I've already been able to share the notes. So we've already been able to introduce this particular topic here, and we've seen what is a company. We've seen the features and the characteristics about a company. We've already been able to see the different classifications of companies. And of course, now in this case, in our previous class, we wound up by having to look at, in this case, what? The principle of separate legal entity. We looked at the principle of separate legal entity, and the exceptions. And the exceptions. You're able to look at the exceptions of the principle of separate legal entity, or you can be able to say the exceptions to the rule in Solomon versus Solomon and Company Limited, or sometimes we say the lifting of the veil of incorporation. So this is what we finalized on having to look at in our previous class, lifting of the veil of incorporation, lifting of the veil of incorporation. So this discussion we've already been able to do. If you happen to have missed the class, please go back and check our previous classes on the LMS. Check our previous classes on the LMS. So today, straight away, I want us in this case to start on the distinction between a company and the other forms of business. So of course, you can be able to recall when in this case I was having to introduce, I indicated to you that if anyone ends up having to ask you what is a company, you have to, in this case, first of all, surprise the person by having to tell him, in this case, it is what? It is a form of business. And therefore, in this case, it simply means it is one amongst the other forms of business, which in this case, we can be able to have. So in this case, we have a sole proprietor. We can have a form of business we call what? A sole proprietor. A sole proprietor. And we can be able to have, in this case, a partnership. We can have a partnership. We can have a partnership, and in this case, we can be able to have a cooperative society. We can be able to have a cooperative society, So we are ideally, in this case, going to discuss and be able to understand if we try to compare a company and these other forms of business. So what in this case are maybe the differences that we can be able to have between a company and a sole proprietor, a company and a partnership, a company and a cooperative society. And therefore, in this case, it is very easy to be able to distinguish these other forms of business with a company. So we already, in this case, we've known the features or characteristics of, in this case, what? A company. What we need to do in this case, we also have to understand what are the characteristics of a sole proprietor, a partnership, and of course, a cooperative society. Once we're able to know the features, then we can easily be able to, in this case, do what? Distinguish. We can easily, in this case, be able to do what? Distinguish. For example, in this case, if I end up having to ask, what are the features or characteristics of a sole proprietor? What are the features of a sole proprietor? You can be able to indicate them there in the chat. Features of a sole proprietor form of business. Sole proprietorship form of business. What are the features of a sole proprietorship form of business? What do you know about a sole proprietorship form of business? What do you know about a sole proprietorship form of business? There's something you must actually be knowing about a sole proprietor. So I can see Zipporah says it is owned by a single person. So single person ownership. So single person ownership is the first one. Single person ownership is correct. Exactly correct. Single person ownership is correct. What else? I can be able to see Kennedy says there is no principle of separate legal entity. Wow, this guy is very brilliant. No principle of separate legal entity. This guy is brilliant. No principle of separate legal entity. It is correct. This principle of separate legal entity doesn't exist in a sole proprietor. I can see Slim says the owner raises capital alone. So he's the one who raises capital alone. So the sources of capital, you can talk about sources of capital. Sources of capital in this case, sources of capital. actually sources of capital. In this case, we can be able to talk about maybe some savings. Maybe in this case, having to borrow from, maybe in this case, it can be friends, or maybe in this case, relatives, friends, or maybe relatives, to be able to get, in this case, what? The source of what? Capital. You people are giving a lot of points. You people are the most brilliant students I've met this year. I can be able to see in this case, Kevin says it is managed by the sole owner. It is managed by the sole owner. The points are coming in quick and very fast. Managed by a sole owner. Managed by a sole owner. That is another feature we can be able to indicate there. It is easy to form and dissolve. That is from Ashley. Very brilliant. Very brilliant. Excellent. Easy to form. It is very easy to form. The procedures to be able to form this kind of a business, they don't actually involve a lot of procedures. It is easy to form and dissolve as a form of what? Business, or even change to another form of conducting what? A business. So it is easy to form and in this case dissolve. So this, in this case, what? Unlimited liability. Maybe you can just be able to indicate, but is in relation to this particular principle here. But let us just indicate there is what? There is unlimited what? Liability. There is unlimited liability. That is very correct. That is very correct. Which other point? Stanley Mutua says, no sharing of profits. The owner enjoys the profits alone. That is very correct. Owner enjoys profits alone. The owner enjoys profits alone. The owner enjoys the profits alone. He doesn't share with anyone, but he ends up having to enjoy the profits alone. But at the same time, he suffers losses alone. He suffers the losses alone. He suffers the losses alone. Calvin says, quick decision making. Very brilliant. Very brilliant. Quick decision making. So it is easy to make decisions. You just consult yourself. You don't have to consult anyone. You are the sole owner. You are your own boss. So in this case, it is very easy to make what decision. So quick decision making. Quick and easy decision making without having to do a lot of what? Consultations. Quick decision making or easy decision what? Making. Quick decision making or easy decision making. What else can we be able to say? Jasmine says less legal formalities. So maybe this one we can be able to relate to this one. So we can be able to say yes, we can also be able to frame this point as what? Less legal formalities when having to form. Less legal formalities, we can be able to indicate here. That is very correct there. Which other points am I having to see here? Limited source of capital, we've mentioned the source of capital. It can be managed by the family or the sole owner. There's no principle of separate legal entities. So those points you're having to mention there, they are actually in this case what? Correct. So there's something I've already been able to give you as a secret as why in this case you can be able to get the differences. You don't have to cram. You just in this case need to know what the features of these other forms of business. Then you know what the features of a company. Then you just relax. You sit back and relax and you wait for the question in the exam. You just sit back and relax and wait for the question in the exam. For example, in this case, if you look at these features, there's a way you can be able to identify a difference. If in this case, you compare with what? A company. For example, in the first one here, if you look at this one, that in this case, you're having to say a sole proprietor is actually owned by a single person, is owned by, in this case, what? A sole person. But if you look at the other side of a company, we say it is actually a private company. The ownership or membership is how many persons? If it's a private company, we say the ownership or membership is how many persons? For a private company, the membership or ownership is how many persons? So I can see Kevin says 2. It is 1 up to 50. Mutua, you have to mention that range. That's what I want you to mention. If the ownership or membership of a private company is 1 up to 50. What about a public company? What about a public company? A public company? What about a public company? Abraham, what do you mean by when you say unlimited? So you need to make your points very clear. So it is 2, a minimum of 2, and there is no what? Maximum limits. So a minimum of 2, and there is no what? Maximum limit. So therefore, in this case, that can be a difference here. While a sole proprietor is actually owned by a single person, a company, it is a private company, it will be 1 up to 50. If it is a public company, a minimum of 2 members or owners, and there's no, in this case, what? Maximum limit. There is no actually maximum limit. When you look at this one, there is no principle of separate legal entity. That in a sole proprietor, we view the business and the owner as having to be one and the same person. There's no distinction between the business itself and, of course, in this case, what? The owner. And therefore, this principle of separate legal entity doesn't exist. Doesn't, in this case, end up having to exist in this case in what? In a sole proprietor. And therefore, all those other features that actually emanate from this principle of separate legal entity do not exist in a sole proprietor. Do not actually end up having to exist in what? In a sole proprietor. For example, having to contract in its own name, having to own property in its own name. It doesn't, in this case, end up having to exist. So if in this case, a property is actually acquired, it's like in this case, is actually the name of what? The sole owner. If in this case, the business is actually under liability or is actually having to be sued, it's like in this case, the sole owner has actually been sued in a court of law. So there is no principle of separate legal entity. But in this case, it does exist where? In a company. The sources of capital. So a sole proprietor has a limited source of capital. You cannot actually end up having to compare to a company, because for a company, the company can be able to sell what? Shares. And then it can be able to have what we call what? Share capital, which is a topic you'll be able to cover later. Still at the same time, the company can be able to go into heavy borrowing, through in this case having to raise what we call what? Debt capital. For example, they can be able to sell what we call a debenture. It doesn't exist in a sole proprietor. For a sole proprietor, you'll actually be so much limited in terms of having to be able to raise what? Capital. You can just be able to utilize maybe your savings, or maybe you can be able to do some borrowings, in this case from friends, or maybe relatives. Then in this case, you can be able to get what? The source or the means of what? Capital. But for a company, the options might actually end up having to be wider, because you can easily be able to sell what? Your shares. Then in this case, it is managed by a sole owner. But now in this case, a company is managed by who? 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 So the sole owner manages the sole proprietorship form of business here. But a company is managed by who? It is managed by directors. So in this case, in a company, the owners, the shareholders appoint a person we call a director, who ends up having, in this case, to do what? To manage the affairs of the company. But in this case, in a sole proprietor, the sole owner can be able to run the business by himself. Someone is having to ask what is actually a debenture. It is an instrument that can, in this case, be sold by the company to be able to borrow, to be able to borrow. So I know you have done a lot of financial accounting. You've done a lot of financial accounting. And of course, also your lecturer for financial reporting will be able to tell you that in this case, when you talk about a debenture, it is simply an instrument that in this case can actually end up having to be sold by the company to raise funds, to borrow. So it is an instrument sold. It basically forms an agreement of borrowing between the company and a third party. So the company is under obligation to pay a principal amount plus, in this case, what? Interest. So if you are a very good student of financial accounting or financial reporting, then you sometimes see this one in your books of accounts or financial statements having to be reported as what? As a liability. As a liability. But of course, you'll be able to learn more about it in topic 5, which we call debt capital. That's what we mean by a debenture. So there's a difference there. We've already been able to say managed by a sole owner, company managed by directors. It is easy to form and dissolve, or in this case, also we can be able to say that point to be given by Jasmine, that in this case, there are less what? Or fewer legal formalities. The procedure of having to form a sole proprietor ends up having to be much easier if you compare to a company. With a company, you need a lot of legal formalities. You have, like in this case, to prepare the articles. You have, like in this case, to prepare to come up with the memorandum. You have, like in this case, to come up with who are the directors. You have to, in this case, submit the documents to the registrar. They have to be assessed. Then in this case, eventually, your business can actually end up having to be formed. A lot of legal formalities, a lot of procedures ends up having to be involved when you're having to form a company, compared to, in this case, what? A sole proprietor. Then in this case, we say the company, for the life to come to an end, there has to be what we call what? Liquidation. which I told you, it is never an easy process. It can even take years before liquidation comes to an end. But in a sole proprietor, quite easy in this case to be able to do what? Dissolve, compared to in this case what? A company. Because for a company, it has to undergo what you call what? Liquidation. And in fact, before that, there could be procedures that can actually be undertaken to try and actually save the company from having to undergo what? Liquidation, which we call what? Receivership, or in this case, sometimes we call it what? Administration. But for a sole proprietor, it's quite easy. So there won't be those tedious processes compared to, in this case, what? A company. There is what? Unlimited liability. We said in this case, when you talk about, for example, unlimited liability, in the case of a company, it is that if it happens, the assets of the company cannot actually fully be utilized, cannot actually be adequate enough, cannot actually, in this case, be adequate enough, in this case, to settle the liabilities, then the personal assets of the owners or the shareholders can be utilized. That's why in this case, we say what? You know what it means to earn, there's no limit, unlimited. So the difference here is that in a company, we can have, not all companies, because we can have unlimited companies, but in a company, we can have a limited liability. In a sole proprietor, a limited liability does not exist. If it happens, then in this case, the business is liable. The personal assets of the sole owner are easily attacked, in this case, to do what? To settle the business liabilities. The unlimited liability does not exist at all in a sole proprietor, but it can exist in a company. For example, if the company is registered as a limited company. But in a sole proprietor, it does not exist at all. In this case, it means the sole owner can be liable for the liabilities of the business. The personal assets at home can actually end up having to be attacked to settle the liabilities of the business. So that is a difference. You can be able to get there. The owner enjoys profits alone. Wow. Wow. How sweet is this? The owner enjoys profits alone. But what happens in a company? The profits are shared in form of what? Dividends. That is a difference. The owner enjoys profits alone. But what happens in a company? The profits are shared in form of dividends. That is a difference. The last one, it is quick and easy to make what? Decisions. It is quick and easy to be able to do what? Make decisions. Because you are the sole owner. You don't have to consult. You don't have to consult anyone. But in this case, in a company, before you make a decision, members of the company at least have to convene at a general meeting to decide and actually be able to pass what? A resolution. Do you think it is quite easy for 100 people to make a decision? It is never easy. But compare this one, in this case, with what? A sole proprietor. A single person decides, today I'm going to sleep. I'm not having to go to open the business, and it can happen because he's the boss, he's the everything. No one can be able to ask him what? Questions. So it is actually very easy to make what? Decisions in what? A sole proprietor. Just connected to this one. It is very easy to keep secrets in a sole proprietor. Just imagine you are the sole owner. You're having to run what? A mitumba business. People think that in this case, that mitumba business of yours is having to thrive. That in this case, you are making a lot of money. But ideally, things are not actually having to work so well. Things are having to go numbers for you. In fact, you are having to struggle, but no one ends up having to know because you are the one who's in this case having to do what? Run the business as the sole owner. You can keep business secrets. Can it really happen in a company? Especially a public company. They have to publish their books of accounts to be out there. If the company is making losses, everyone knows that in this case, that company, there's nothing there. There's nothing there because they are making losses. But you are the sole owner of the Mutumba business. It is making a lot of losses, but no one can be able to know because in this case, you are the one who runs the business. You can easily be able to do what? Keep business secrets. It is quite easy to keep business secrets in a sole proprietor compared to, in this case, what? A company. So what are we having to say? You don't have to cram. You just have to know what? The features. And that is dusted. That is what done what? Done and dusted. You can be able to get what? The differences from the futures. Alternatively, they can be able to ask, what is the advantage of one over the other? You just have to know what? The features. You don't have to cram. The advantages of this one is this and this, each and every point like that. You just know the features. Then you sit back, relax, and wait for that question. For each and every, in this case, what feature, you might identify either it having to be an advantage over the other, depending upon how you can be able to argue. Or it can be a disadvantage over the other, depending upon, in this case, how you can be able to do what? Argue. It just depends with, in this case, how you can be able to end up having to do what? To argue. For example, you talk about, in this case, what? Quick and easy decision making. This is like an advantage over, in this case, what? A company, because you can make decisions very fast. And then in this case, the procedures or processes become very easier. In this case, what? In a sole proprietor compared to what? To a company. The owner is having to enjoy what? Profits a lot. It's like, in this case, this one is like an advantage to the owner of the business over what, in this case, a company. Because now in this case, in a company, you have to share what? Profits. When you talk about, in this case, sources of capital, this is like now in this case a disadvantage because you are limited in terms of capital. But in a company, there's a wider source of what? Capital. So this one happens to be a disadvantage of a sole proprietor over what? Compared to a company. On that other side of a company, that one ends up having to what? An advantage. The principle of separate legal entity. So this one basically simply means is a disadvantage because it brings upon, in this case, what? So many disadvantages to the business owner or the business itself when you compare with a company. For example, now in this case, the liabilities of the business become like those ones of what? Over the owner, which is a disadvantage. Just imagine, in this case, you are Range Rover at home that you've been able to park in your parking lot. All of a sudden, auctioneers are having to appear that in this case, you have a liability in your business as a sole owner of a business. Then they basically tow it off. It's a disadvantage. But now in this case, if you compare with a company, you're just sitting back, relaxing at home. You are a shareholder at Safaricom. You don't want to know what are their liabilities. There's no way in this case they can actually end up having to knock at your door and start having to tell you that Safaricom, when you are a shareholder, there's a liability. You need to go and settle. It can't happen. They can't attach your personal assets because this is what? A limited company. So what are we having to drive home as a point? You just have to know the features. Then you sit back and relax. Let any question come. It shouldn't trouble you because now in this case, you can get the differences, you can get the advantages, you can get the disadvantages of one over the other. One over the other. So we can now in this case go to what? A partnership. So we have in this case, this other one we call what? A partnership. So what are the features of a partnership? Which features do you know of a partnership? You can be able to mention them there in the chart. What are the features you know of a partnership? The features you know of a partnership form of business. What are the features you know of a partnership form of business? You must be knowing some features. Very interesting features. You must actually be knowing them. Zipporah, what are the features of a partnership? James, what are the features of a partnership? Features of a partnership that in this case you know of. Features of a partnership that in this case you know of. So I can be able to say there's voluntary or open membership. If it is Kitty, you can put off your video. Put off your video. I think it is disrupting the students there. If it is, that is okay. That is quite okay. If it is now you are our friend. You are now our. I can be able to see people are giving points here. I can be able to see people are giving so many points here. So the first one here is created by a mutual agreement. So in this case, created through what we call what? A partnership agreement. So it is created through what we call a partnership agreement. Partnership agreement. There's a partnership agreement. It's through what we call a partnership agreement. Which other points am I having to see here? So that's from Wambui. Then in this case, Zipporah says 2 or more members. So it is owned, it is in this case owned by 2 up to 20. It's normally 2 up to 20 persons. 2 up to 20 persons. That is a normal partnership business. But for example, in this case, it is a partnership business that is actually involved in maybe banking or insurance business. The recommendations under the relevant acts, they are supposed to be only 2 up to 10 persons. But the normal partnership business under the Partnership Act is actually 2 up to 20 persons. Which other points are you friends having to give me there? Unlimited liability. So of course, in this case, we can also be able to say there is no, so there is in this case what? Unlimited liability. Unlimited liability. Or we can be able to say there is no also principle of separate legal entity. No principle no principle of separate legal entity. There is no principle of separate legal entity. And what else is there? Sharing of profits. Yes, they do share profits. So there's sharing of profits. Sharing of profits. Profits are shared. Profits are shared amongst. Profits are shared amongst the partners. So that in this case, our feature that you have there. Profits are shared amongst what? The partners. So the partners contribute what? The capital. So the capital is contributed by the partners. Capital is contributed by the partners. Capital is contributed by the partners. The capital is contributed by the partners. That is correct. So there is in this case what? The partnership contributes in this case to what? To the capital. Co-ownership of property, or the property is actually owned by the partners. It is governed by the Partnership Act. This from Jen. Wow. You people are the most brilliant students I've met this year. You people are the most brilliant students I've met this year. So in this case, it is regulated. It is regulated by the Partnership Act. Exactly regulated by the Partnership Act. Exactly regulated by the Partnership Act. It is regulated by the Partnership Act. It is regulated by the Partnership Act. Which other point are you having to see? GMO says a new partner joining must be accepted by the existing what? Member. So that basically will be upon in this case what? The agreement. So they'll be able to in this case follow the agreement, which in this case they'll have to in this case follow the procedures as to how they can be able to admit what? A new partner. The board is not clear. I don't know why the board is not clear. So sharing of risks among the partners. There is no perpetual succession, which basically comes here. Under this one, no principle of separate legal entity. Under this one, no principle of separate legal entity. The business must be lawful. It must, in this case, as per the partnership, in this case, what? Agreement. It must be as per the partnership agreement. It must be as per the partnership agreement. It must be as per the partnership agreement. So I can see one of our friends is saying the board is not clear. Let me try to assist you, kid, a bit so that it can be a bit better. But it is not far away from clear. It is not far away from having to be clear. It is not far away from having to be clear. So there it should be very clear. There it should be very clear. There it should be very clear. So there it should be very clear. There it should be very clear. You know, you might be thinking the board is not clear, but you know also my handwriting, it is one of the best. My handwriting is one of the best. It is one of the best. It is one of the best. That's why I told you, don't focus on having to write a lot. So you focus on the notes you have. My handwriting is one of the best. It is all. You might be thinking the board is not clear. Here it is my handwriting. The registration is not compulsory. And those you are saying registration is not compulsory. Registration is not compulsory. So which point haven't we mentioned here? Which point haven't we mentioned here? Is created through the partnership agreement. It is owned by 2 up to 20 persons. So the partnership is actually managed. The partnership is managed by, can be managed. The partnership can be managed. The partnership can be managed by the partners. The partnership can be managed by the partners. So they actually participate in the management of the partnership. So for example, in this case, if we have doctors who have actually been able to create a clinic, so we have one of the doctors who are specialized in dentistry. So he'll basically be handling the dentistry area. We have another one in this case who has actually specialized in pediatrics. He'll actually in this case focus on having to, in this case, deal with what? The children matters, children like that. So they can actually be able to, in this case, by themselves, manage in this case what? The partnership business. They can actually, in this case, by themselves, end up having to manage the partnership business. So like that. So if you look at all these features, then we can easily be able to also be able to identify in this case what the differences. For example, if you talk about in this case, it is created through a partnership agreement. So this partnership agreement will be able to guide us to how the partnership will likely end up having to be managed. So in the case, for example, in this case, they have to understand how they're having to run the business. then they can be able to look at the partnership agreement, which becomes like in this case, there are rules and of course in this case regulations, guiding as to how the partnership can actually end up having to be governed or to be managed. If you look at the other side of the company, there is a document we call in this case the Articles of Association, and also we have in this case what we call a Memorandum of Association. So this ends up having to be the regulatory documents that should be able to guide as to how the affairs of the company will likely be managed. So while on the other side of the company, we have what we call an Articles of Association, which we are going to learn more about in our next topic. And also in this case, we have the Memorandum, which we are also going to learn more about in our next topic. So when you talk about the articles, it's like the constitution of the company. These are documents that sets out the internal rules and regulations to govern the affairs of the company. When you talk about the memorandum, it's simply that document that will be able to explain the company more to the outside world. In the memorandum, you'll be able to get, in this case, for example, the name clause, which will be more about the name of the company. You'll be able to get about the registered office clause, which will likely basically be more about the registered office of the company. You can be able to get, in this case, the capital clause, which will be more about, in this case, the capital with which the company was registered with at the registrar's office. With these particular two documents, then you can be able to understand as to how, in this case, the company is having to be managed. So these articles happens to be like, in this case, the constitution of the company. It just contains, in simple terms, the internal rules and regulations governing the affairs of the company. It just contains the internal rules and regulations governing the internal affairs of the company. That's the Articles of Association. While in this case, in a partnership, we'll be able to have what we call a partnership agreement. A partnership agreement. So these ones you don't have to worry about them, because now you're going to look into deeper matters concerning articles and the memorandum in our next topic, which is actually in this case formation of companies. When you look at this one, Zipporah, look at this one. Are you seeing a difference? It is quite obviously it is there. Owned by 2 up to 20 persons. What about a company? If it's a private, 1 up to 50. If it's a public company, a minimum of 2, and there's no set maximum limit. If you look at the third one, unlimited liability, which is more so in this case connected to this one. So in this case, in a partnership, there's not really in this case, maybe in this case, what we call limitation in terms of liability. But of course, nowadays we have partnerships that in this case have also features of a company. We call them LLPs. Limited liability partnership. So nowadays, most professional firms, especially audit firms, register in this form. So these are partnerships that has, in this case, some elements of a company and some elements of, in this case, a partnership. But a normal partnership business doesn't have, in this case, limitation in terms of liability. But for this one, it has. It is known as an LLP, limited liability partnership. So professional firms nowadays, they tend to register more in this form. So which in this case is simply a partnership that has elements of a partnership and some elements of a company. For example, in this case, in terms of limitation of liability, this one does have, in this case, a limited liability. But a normal partnership business, which is not an LLP, in this case, will likely not have, in this case, a limited liability. It simply means that in this case, the owners or the partners. In any case, in this case, the partnership business is actually liable. The personal assets of these partners at home can actually easily be attached, in this case, to settle the liabilities of the partnership business. Then in this case, there's no principle of separate legal entity, but in this case, in a company, we do have it. For example, in this case, when you talk about assets having to be acquired in a partnership, they likely ideally be registered in the names of all the partners. But now in this case, when you talk about, in this case, a company, it likely be registered in the name of the company. So we don't actually, in this case, view a partnership having to be distinct and separate from the partners themselves. They're like, in this case, one and the same person. It doesn't, in this case, occur in a company. A company, as per the rule in Solomon versus Solomon and Company Limited, a company is a distinct, separate person under the law from, in this case, the owners or the shareholders. It will be able to exist on its own. And as a result of this, we say predominantly so many features end up having to arise. Perpetual succession. So in this case, for example, in a partnership, in the agreement you haven't agreed, then in case of exit or death of a partner, it means in this case, death and exit of a partner can lead to the end of the life of the partnership. But in this case, you say in a company, there's what we call perpetual succession. The life of the company doesn't depend upon, in this case, the life of the owners or the shareholders. the company will still actually be recognized under the law, unless, in this case, it is liquidated. It is done what? Liquidated. Is when you can be able to say, indeed, now the life of the company has come to end. So therefore, in this case, in a partnership, there is no principle what? Separate legal entity, like in this case, not in a company. Then profits are shared amongst what? The partners. But of course, now in this case, also in a company, we do say profits are shared amongst what? The shareholders in form of what? Dividends. But of course, there's a difference you can still be able to get here. What is the difference? Those who have done a lot of, in this case, public finance and taxation, you'll likely be told that in this case, in a company, we have something we call what? Corporate tax. Corporate tax. This corporate tax is normally 30% on the profits of the company. So in a company, we do tax the company directly because it's a legal person on its own. In a partnership, we don't tax the partnership. The profits have to be shared amongst the partners. Then the partners will be taxed individually. They'll be taxed individually. The profits have to be shared amongst the partners. Then the partners will be taxed individually. So those who have done PFT, they understand what I'm having to say. So with my little knowledge of tax, I also know. With my little knowledge of tax, I also know that in this case, in a company, they'll tax the profits of the company. It is normally at 30% of the profits of the company. We call it corporate tax. While in this case, in a partnership, you don't tax the profits of the partnership directly. You'll have, in this case, do what we call what? Distribution amongst the partners. You'll have to distribute amongst what? The partners. Then once you've been able to distribute it, then in this case, you can actually be able to now tax them individually. So you get a difference there. You get a difference there. You get a difference there. Then in this case, the capital is contributed by what? By the partners. So the partners are able to contribute the capital. So it's normally in this case, this one does maybe 60,000, this other one 70,000, this other one 80,000. Then eventually in this case, they put together, they're able to form what? The business. So for them, they do not actually end up having to sell what? Shares. So for them, they contribute capital by themselves as what? As parties. While in this case, in a company, there's a wide range of source of capital you can be able to get from. In this case, you can be able to sell shares, or you can sell that instrument. We are having to call what? Debentures. And therefore, you're able to raise what we call what? Debt capital. So the partnership in this case is regulated by the Partnership Act, while in this case, companies are regulated by the Companies Act, while in this case, companies are regulated by the Companies Act. Do you see that difference? The law having to regulate these kind of businesses are quite distinct. In this case, for a partnership, we rely upon the Partnership Act to understand how you can be able to manage or govern or be able to run a partnership business. While in this case, for a company, we rely upon the Companies Act. The Companies Act. For partnerships, in this case, they can be able to manage the partnership business by themselves as the partners. While in this case, in a company, they do end up having to appoint, in this case, what? Directors. They do end up having to appoint, in this case, what? Directors. So that is part of the difference that you can be able to have with regard to, in this case, what? Partnerships, and of course, in this case, what? Companies. So you have now, in this case, known the trade. Sometimes they can ask the advantages of this one and the other one. I've told you, you have to know the feature and look at the feature critically. Can it be an advantage over the other one? Or sometimes, based on your argument, so sometimes you used to do what we call what? Debate. You used to have a debate in school, and you had very nice topics. That in this case, mom is better than dad. Mom is better than, in this case, what? Dad. So there are those who are having to defend mom is better. And there are those who are having to defend dad is what? Better. So why is mom better? Mom is better because when he comes for visitings, he's able to come with what? Shopping. But dad, when he comes for visiting day, he comes with a newspaper. So mom at least brings some food, so we can be able to sit in the field and we're able to eat and just enjoy. But when dad comes, you just know, he's having to come with a newspaper in his hand like that. Then the other side, they also defend dad. They say when dad comes, the pocket is heavy. So at least pocket money, there, you get something nice. But when mom comes, it is just shopping. Then pocket money, 200. Then you are left to survive up to the end of the semester. I don't know whether you people experienced that. So when that comes, the pocket is Maybe so pocket money, you know, but of course now in this case you won't sit in the field, so having to just enjoy. But now when so so the opposite happens. So you wish mom comes or dad comes. Who can you wish in this case comes? Who can you wish in this case comes for that visiting? Is it mom or dad? Is it mom or dad? I can see people are saying dad. So people are saying people are saying dad should come. Hmm? Food all the days, food all the days. Someone is having to say at least food, food all the days. So you have to defend. So depending upon your argument, you can be able to say dad is better than mom. So the same case here. Depending upon your argument, some of the points you might realize they could be an advantage over the other. Also, you can argue the other way and say, no, this one is a disadvantage over this other one because of this and this. So you just need in this case to look at what the features or the characteristics like that. And of course, you can be able to see the difference. And of course, in this case, what maybe the advantages or the disadvantages of one over the other. So you can go to the final one, which in this case is actually what cooperative societies, which in this case is actually cooperative societies, cooperative societies, cooperative societies, which in this case is actually cooperative societies, cooperative societies. So we can in this case try to list here the features of a cooperative society. And we can be able to list here the features of a cooperative society. Anyone who knows a feature of a cooperative society? Features of a cooperative society. Features of a cooperative society. What are some of the features you might end up having to list for a cooperative society? Anyone who knows any feature of a cooperative society? Features of a cooperative society. So voluntary membership, voluntary and open membership. So voluntary and open membership is correct. Voluntary and open membership. Voluntary and open membership is correct. And number two, what else can you be able to say? Democratic management. So in this case, there's actually what we call what? Democratic management. Democratic management. Through appointment of a committee, through appointment of a management 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 committee. They are formed for the well-being of the members. So they are formed. So primary objective to serve members. The primary objective is to serve members. Primary objective. The primary objective is to serve the members. The primary objective is to serve what? The members. The primary objective is actually to serve the members. And you people are bringing in points very quick and very fast. This is the principle. This one now, in this case, we have it is a corporate entity. So there's the principle of separate legal entity does exist. Principle of separate legal entity does exist. The principle of separate legal entity does exist because it's a corporate entity. What else? There is equal contribution of resources. This one's from GK. I don't know what GK means, Government of Kenya. So at least you must be able to put your name in full or your first name. Now I'm having to call you GK. So which is meaning, I don't know, it is meaning Government of Kenya. Tuko na serikali in the class. Tuko na serikali in the class. Tuko na serikali in the class. So in this case, you're having to say what? You're having to say that the source of capital is actually in this case what? Homogeneous. Source of capital we can be able to say is membership. So source of capital is membership fee. Is membership fee. Is membership fee, exactly membership fee. And sometimes we can be able to get donor funding and government grants. Donor funding and government grants. Donor funding and government grants. So what else are we having to? Equal voting rights. So we have equal voting rights is correct. One member, one vote. So equal voting rights is correct. Equal voting rights is correct. One member, one vote. Equal voting rights. Limited liability. So of course, when you talk about limited liability, you're talking about limited liability. All those other points come here. So limited liability is as a result of the principle of separate legal entity. So Ashley and my friend can sue or be sued in their own name, sue or be sued in own name is because this principle does exist. So those are points that still emanate from here. This particular principle, it can sue or be sued in its own name. So those are the points that exist here. So there's perpetual succession because now in this case, it doesn't exist as a result of the members, or in this case, what? Those who are having to govern it. So it exists on its own. It exists on its own. It exists in this case on its own. Let me try to autonomy and independence. It actually in this case operates independently. So which other point have it to put? So maybe you can be able to get it first of all, start having to get a difference from these ones. We can start of all start having to get it. So this one you haven't been able to mention. It is regulated by the Cooperative Societies Act. Regulated by the Cooperative Societies Act. I think it is an act of 2008 or something. Cooperative Societies Act. Regulated by the Cooperative Societies Act. Regulated by the Cooperative Societies Act. Regulated by the Cooperative Societies Act. So examples I'm going to give you. You don't have to worry. I'm just going to give you. So let me first of all in this case try to explain what is a cooperative society. So cooperative societies are simply basically bodies or cooperative bodies that in this case are actually formed for the purpose of having to serve the members. They are majorly formed for the purpose of having to serve what? The members. So majorly in this case, they are actually formed by persons of the same trade, or maybe in this case, what? Profession. That is majorly what happens. Not all of them, but majorly, they'll actually end up having to be formed by persons of the same trade. People who actually basically participate, maybe in the same economic activity, or maybe the same trade, or maybe profession. An example could be that in this case, tea farmers at Kericho, they see the need of, in this case, what? Coming together in form of what? Numbers. And then in this case, they know once they come together and they actually registered as a cooperative society, they can actually be recognized. And now in this case, they can get support from the government. Through that membership fee they are able to contribute, they can be able to pull resources together and they can be able to overall benefit as tea farmers in such that in this case, they can get farm inputs very easily through the cooperative societies. And then in this case, it makes them having to even participate more and actually even be able to benefit more from this economic activity they're having to do it, undertake. So eventually, they might actually end up having to upgrade and go to the extent of, in this case, even having, in this case, to fund the members through, in this case, what? Maybe loans. So that in this case, they can be able to facilitate their business activities and, of course, improve their livelihood. Those are what we call what? Cooperative societies. Cooperative societies. So they are majorly formed by people what? Of the same trade or profession. Majorly, their primary objective, listen, Zipporah. Their primary objective is to serve the members. They want, in this case, to improve the members themselves. First of all, that is like their major objective. Like when you talk about tea farmers or maybe dairy farmers, they want, in this case, that the members are able to benefit through this what? Economic activity of having to undertake what? Dairy farming. So they know once they come together, all the dairy farmers, they can be able to form what? A cooperative society. They'll come up in this case with, for example, measures that can be able to improve this what? Dairy farming. In what sense? Easily they can be able to, in this case, set up a milk processing plant. And therefore, in this case, the members can easily be able to supply the milk there. It is processed, it is actually sold, and they pay back the members. Assume you are a single farmer. Can you be able to set up this milk processing plant? It might not be very easy. But in this case, assume you come together, you form numbers. You can easily, in this case, be able to do what? Fully participate in your economic activity, your trade, because now in this case, you know, if in this case, I want, for example, to know somewhere I can be able to take my tea. We have a cooperative that has already been able to do what? Set up, in this case, what? The milk processing plant, or they have identified a market where we can be able to sell, maybe in this case, what? This milk. Then in this case, once they get the money, they're able to pay us. Or maybe in this case, the government basically in this case approaches the cooperative society because it is formally registered. They're able to give them donor funding. And they say that in this case, for example, fertilizer is going to be subsidized. In this case, you're going to end up having to get at a very cheaper price. Then you can be able to do what? Distribute amongst what? The farmers through what? The cooperative society. That's what we mean by in this case what a cooperative society. That's what they actually do. That's what in this case they actually end up having to do. And of course, majorly their membership is normally drawn from a very specific area. If it's coffee farmers in Muranga, they come from there, Muranga. If it's tea farmers in Kericho, they come from there, in Kericho. If it's dairy farmers in Limuru, they come from there, in Limuru. So they'll set it up there. They'll set it up there. So the government in this case usually actually encourages the cooperative movement because it is believed through this cooperative movement now in this case, people are able to improve what their livelihoods. They can be able to improve what their livelihoods like that. As a result of in this case, it's having to focus on what the members, having to focus on the members. Then once in this case they have already been able to establish themselves, they even get involved in activities that not only will end up having to benefit the members themselves, but now in this case, they could come up with, for example, social amenities where they are located. For example, they can set up a hospital to serve the members. They can basically, in this case, set up any other social amenities that is actually very relevant to the members themselves, but ideally it will be able to serve the entire community. It will be able to serve the entire community. And that is basically what in this case they'll likely be involved in. Membership is just open, so you can easily be able to join through having to pay what you call a membership fee. And that's of course one of the reasons why in this case they're able to raise what? Their capital. They're able to raise their capital. So that's what we call what? A cooperative society. So therefore, in this case, if you look at these features we've just been able to mention here, you will easily be able to identify some differences. But in this case, you compare with what? A company. For example, here, I've been able to say that in this case, you've been able to say, in fact, you're the ones who gave me these points. So voluntary and open what? Membership. It's just voluntary. And in this case, what? Open membership. So on this point, I've been able to mention that the membership for a cooperative society, majorly, it is normally drawn from a very specific area, in a particular area. It could be a county, it could be maybe in this case, a sub-county, somewhere. It is actually very, very specific area. But in this case, when you compare with a company, the membership of a company is usually drawn from a very wide area. For example, if they are actually shareholders at Safaricom, you'll end up having to realize they are just all over the country. Not in this case limited to a very specific area. They're just in this case drawn from what? All over. So like that. So you can be able to get a difference there. Then there's what we call what? Democratic management, through what in this case appointment of a management committee. What happens here? The members of that cooperative society, they choose amongst themselves who will be their chairman, who will be in this case the secretary, who will be the treasurer. They in this case appoint a committee among themselves, which will likely end up having to do what? Manage the affairs of that cooperative society. But now in this case, in a company, we do end up having to appoint in this case what? Directors. We appoint directors who are not in this case necessarily actually in this case what? The initial members or the members of the company. But eventually they become members because they'll be able to take up something we call qualification shares. So in a company, we do have what? A board of directors. Here, we have a management committee that is actually appointed democratically by the members through having to vote and having to decide who will actually basically be amongst the management committee to manage what? The affairs of what? The cooperative society. Here also you can be able to get another difference. Here also you can be able to get what? Another difference. Simply because the cooperative society is having to choose the management from, in this case, what? The members themselves. Sometimes cooperatives might actually end up having to suffer in terms of limitation of what? Management expertise. But in this case, with a company, you appoint directors. Before you appoint a director, you have to know, has he ever served as a director? Does he have, in this case, the capacity? It's not that just in this case, what? Having to blindly choose someone. You as shareholders, your interest. You must be able to put there someone who's actually, in this case, what? Reasonable. But when you choose from the members, sometimes some of these members haven't actually been able to even step in this case, what, a management class. They don't have, in this case, how they can go to manage their affairs. So every time they are wrangled, they lack expertise. So they are likely to suffer from lack of what, management expertise. So they can go to get another difference there. Then the primary objective is to serve the members. Profit making for this kind of bodies will just end up having to come as a secondary. So we start with what? Prima. Our prima in this case is to ensure that our members are satisfied. Are we serving them better? Are they getting farm inputs? Are they getting a return on, in this case, what, their economic activity? Do they have somewhere they can be able to supply that these particular items or maybe this particular produce they're having to produce? We are trying to, in this case, serve our members. Are they getting the finances, in this case, for example, to run their economic activity? Once that has been fulfilled, then in this case, we go to SECO. Our SECO, in this case, now we can be able to think about having to start making what? Profits. Starting having to do what? Make what? Profits. So the primary objective in this case is normally to serve the members. But for a company, the primary objective is to make profits. Shareholders are there in this case to get what? Dividends. So no way in this case you'll end up having to relax as directors and think things will likely in this case be quite okay if you haven't made a profit. You have to make what? A profit. But now in this case, this one here, they just focus part of it on having to what? Serve the members. So the principle of separate legal entity does exist, which is the same in the case of a company. That is a similarity there. Then the source of capital here is through what, in this case, what we call what? Membership fee. While in the case of a company, is through, in this case, what? Sale of shares. And then it is able to raise what? Share capital. Here you contribute what we call what? Membership fee. Or sometimes you can get donor funding from the government. That's why you have the Ministry of Cooperative Societies, which is headed by who? It's headed by Oparanya. You know Oparanya. Oparanya is the one who is in that ministry. You can see there's a dedicated ministry in the government to focus on matters what? Cooperative movement. So the government is usually very lenient, and in this case, so much supportive of the cooperative movement. So they can be able to get donor funding from the government, or in this case, they can get some grants. So they could be people who can be able to voluntarily volunteer and give them some grants. So we call them government grants. Government grants. In your financial reporting, your lecturer will teach you about government grants and how they are actually accounted for. So these are part of the institutions that would end up having to get a government grant. So they get that support. That's how they raise their capital. But in the case of a company, it is through what we call debt capital, having to borrow, or in this case, having to do what? Sell shares. Then there's something also there you can be able to mention as a difference, just from the same point. When you talk about this membership fee is usually in this case homogeneous. While in this case, in the case of a company, it is heterogeneous. Homogeneous simply means it is uniform. You know, in a cooperative society, you'll likely be told membership fee is 2,000. So everyone will likely be contributing in this case, what? 2,000. But in the case of the company, it depends upon your financial strength or muscle. Financial strength, or in this case, what? Muscle. And therefore, in this case, it means our friend Jasmine can actually be able to acquire shares worth 10 billion. While in this case, our other friend, James, or can be able to, in this case, acquire shares even worth what? 30 million. So you can see it is not uniform. It just depends upon how much can you be able to afford. So it is heterogeneous for the case of the company, but for the case of a cooperative, ends up having to be what? Uniform. Equal voting rights. So one member, one share, one vote. One member, one vote. But in the case of a company, your voting rights will likely basically be dependent upon the number of shares you hold. The more shares you hold in a company, the more voting rights you have. The more voting rights you do what? You have. So, but in this case, in the case of a cooperative society, because now in this case, the membership fee is uniform, membership is uniform like that, so it has equal voting rights. But in the case of the company, the one who has 30 million has more voting rights than the one who has what? 10 million as the shareholding in the company. It is normally dependent upon the number of shares you hold in the company. That gives you, like in this case, the percentage you're having to control in the company. So the more percentage you have in terms of shareholding, the more powerful you will be. So let's assume in this case, all of us have been able to form a company. So the 67 of us have been able to form a company. And there's only one person. His name is Lubaha. His name is what? Lubaha. This Lubaha guy, in this case, has 60% of the shareholding of the company. While all of you, the other 66, you have in this case 40%. So this guy will actually basically be controlling the affairs, because when it comes to having to make decisions, when he votes, he has already been able to contribute 60% of the votes. When he votes, he has already been able to contribute to 60% of the votes. It's as a result of him having to control 60% of the shareholding. So in the case of a company, it's normally dependent upon the shares you have. The more shares you have, the more voting rights you have, the more powerful you will be in the company. So it means you guys cannot actually be able to make a decision without me having to approve of it or vote for it. So in this case, it simply means things will actually end up having to go marambas for you in this company, because I'll basically disturb and bring a lot of trouble for you. If we want to make a decision, first of all, I have to approve. I have to approve. I'm the bazoo there. I'm the bazoo there, because I'm controlling 60%. So it's normally dependent upon what? The shares. Regulated by the Cooperative Societies Act. Well, in this case, in the case of a company, it is regulated by the Companies Act. Exactly, regulated by the Companies Act. So those ends up having to be the difference between, in this case, what? The cooperative society, and of course, in this case, what? A company. So they haven't tested this one for quite long. So for quite long, but you never know. Maybe it will likely end up having to be tested in the coming exam. So we can have a break of, in this case, like 5 minutes. Then when we come back, I want us, in this case, we see whether we can be able to start on the next topic, which is likely, in this case, formation of companies. A break of 5 minutes will be okay. Yes. So welcome back. So confirm there whether we are back. So confirm whether we can continue. You can say yes. Yes, I can see you people are saying yes. I can see Calvin, James, Brian, Franklin, Irene. So DK, Alice, you are saying yes. So we can start on topic number 2. So let me not look at the questions for now. Let me first of all start topic number 2. But we'll just look at the question. So I want in this case to introduce topic number 2. Topic number 2, it is known as formation of companies. Formation of companies. So under this topic, what you're going to learn about is ideally how can you be able to form a company? How can you end up having to form a company? And what are some of, in this case, the prerequisites or requirements in this case regarding formation of companies? More so in this case, under what? Under the law, under the relevant governing laws. What are the requirements regarding as to how a company could actually end up having to be formed? So we learn about what is promotion and who is a promoter. We look at the duties of this person you're having to call a promoter. There's something we call pre-incorporation contracts. The procedure of having to incorporate a company in Kenya. Then in this case, we look at the articles and the memorandum, which I've mentioned earlier. But now we'll be able to delve deeper into what is actually the articles and what is actually the memorandum. Then we'll come across now, in this case, another very famous case law in company law. So the second one. So the first one was actually Solomon versus Solomon, which we saw in this case, what the exceptions. We'll come across now, in this case, another famous one in this topic. We call it the Royal British Bank versus Taquant. Sometimes we call it the indoor management rule, or we just refer to it as the Taquant case. The Taquant case. So we'll see what was in this case actually provided for under this case law we call the Royal British Bank versus Taquant, or the Taquant case. So promotion. What is in this case is actually promotion. What do you mean by the term promotion? Promotion, we can be able to alternatively end up having to say, please record. The class is being recorded. So it is being recorded. You don't have to worry. In this case, when you talk about promotion, sometimes we can be able to alternatively say incorporation or formation of companies. So they mean the same. So in promotion, incorporation, or formation of companies, just the same term. So ideally promotion, it is that process that in this case is actually undertaken to set up or to form a company as a going concern to be able to exist for the foreseeable future. So remember, in this case, I told you that in this case, when you talk about a company, it is a legal person. Nimutu is a person. But you know, in this case, for a natural being like me and you, we come into existence through, in this case, what natural means. Right? But in this case, for a company, an artificial process has to be undertaken, which now in this case, we end up having to call as what? Promotion. It is a process for a company to come into existence, a process undertaken artificially. So that's what in this case we are trying to delve deeper into, having to understand how does it actually occur or end up having to happen. So when you talk about promotion, it is that process of having to set up or to form a company to exist for the foreseeable future, or to exist as a going concern. Who is this person? This person who undertakes this process, we normally refer to him under the law as having to be the promoter of the company. The person who end up having to undertake all this process of having to form a company, we refer to him as the promoter of the company. Promoter of the company. This promoter will undertake a number of duties or procedures to ensure that the company has actually been able to be formed. So number one, be able to suggest or decide upon what will be the name of the company. Each and every company does have a name. So in this case, the person will likely end up having to, in this case, ensure he has actually been able to propose or suggest what will likely be the name of the company is, in this case, what? The promoter. He'll, in this case, decide upon what is the main purpose, what are the objectives as to why the company is having to be formed. What is the essence or reason of having to form the company? And of course, later on, we are going to see that these objectives are normally, in this case, set out in what we call what? Memorandum of Association. So he'll decide upon what are the objectives or main purpose as to why the company has actually been formed. The capital with which the company will be registered with at the registrar's office. We call it the authorized capital. He also decides upon that capital. The extent of what the liability. Are we going to form, in this case, a limited or unlimited company? The location of the registered office. What will be the exact registered office of the company? Remember, we said for a company, it should be able to have what we call a residence. This residence is normally determined by having to, in this case, indicate on the formation of the company where exactly is the registered, where is the office of the company. So these are part of, in this case, the propositions he has to be able to come up with, in this case, is having to, in this case, form a company as a promoter. So that happens to be one of what his duties. He'll be able to draw up the internal rules and, of course, in this case, what regulations. Ideally, this is what I was having to, in this case, explain to you as what? As the articles. He'll come up with the articles of association. He'll come up with the constitution of the company. The articles of association is like the constitution of the company. It ideally, in this case, sets out the rules governing the internal affairs of the company. The same way we've been able to see in a partnership, we have like a partnership agreement. The same case, in this case, in a company, there'll be a document having to guide, for example, in this case, how the internal affairs of the company can be governed. We refer to it as what? The articles of association. There'll be, in this case, having to come up with what we call what? The memorandum of association, which in this case now explains more about the company to the outside world. Anyone having to look at this document, he'll try to, in this case, get like a deeper understanding about the company. For example, from this document, he can't be able to know what are the objectives as to why the company was actually formed. He'll be able to know, with regard to the share capital of the company with which the company was registered with, how much is it? He'll be able to know, indeed, is the liability of the members in this company limited or not? So there are a number of, in this case, what clauses or paragraphs that in this case can actually be provided for in the memorandum, just to be able to explain more about the company to the outside world. What are we having to say? The articles is like the constitution of the company. It sets out the internal rules and regulations governing the affairs of the company. What about the memorandum? It explains more about the company to the outside world. Any third party outside the company having to look at this document, he can try to, in this case, like in a summary, be able to understand what the company is all about. In the memorandum, we have like the name clause. We have, in this case, association clause. We have, in this case, the capital clause. We have the registered office clause. From these particulars we're having to mention about clauses, then if you read them, you can be able to easily be able to understand more about the company if you're a third party outside the company. So the promoter will be able to ensure these documents are actually in place when the company is having to be formed. He will nominate, or in this case, propose, when the company is having to be formed, who will be the first directors of the company? Who will be the first auditors of the company? Like the first bankers of the company? Who will be the first company secretary of the company? These are, like in this case, the key officers who are in this case needed in the company. He'll propose when he's having to do what? Form the company. Of course, later on, we'll be able to, in this case, learn and be able to understand. For example, when you talk about an auditor, formally, how is he actually end up having to be appointed as what? As a company auditor. When you talk about a director, formally, how does he actually end up having to be appointed as a director? But on formation, the person who plays this key role of having to propose, these officers will be able to commence when the company is having to be formed. In this case, exactly what? The promoter of the company. He'll prepare, in this case, what we call our prospectus. In any case, he's having to form what? A public company. Remember, we said there are a number of companies or types of companies that can actually end up having to be formed. We can have a limited company, we can have unlimited, we can have public, we can have private. Assume in this case, is having to form, in this case, what? A public company. Remember, we said for a public company, it can invite the members of the public to buy into its shares. So if it's a public company, it means that in this case, he'll prepare something we call a prospectus. What is a prospectus? It is simply a notice, advertisement, having to invite members of the public to buy into the shares of the company. We call it a prospectus. If it happens, he's having to form a public company. That's what he's having to register. He'll have this mandate to initially come up with the very first prospectus that can be able to invite members of the public to buy into the shares of the formed company. That is, in this case, a duty he'll be able to play. If in this case, he's having to form what? A public company. He'll enter into contracts so far as necessary to enable the formation of the company. These contracts, we call them pre-incorporation. We know what you mean by pre, just before the company is incorporated. Remember, we'll be able to conclude that in this case, the company has come into existence, has actually been born when the register of companies, after all this process by the promoter, he has been able to issue a certificate of incorporation. So the promoter is having to undertake all these procedures ensure the register of companies is able to give him a certificate of incorporation. Once that certificate is issued, now we say the company has been born as a person under the law. But anything having to happen before that, even during these hulabalus and all these processes of having to form a company, proposing the name and all those, the company is yet to be formed. All these requirements have to be fulfilled by the promoter for the company to get a certificate of incorporation. So therefore, any contract being entered into just to support or enable the company having to be formed, we call it a pre-incorporation contract. For example, quite early in advance, this promoter might try to identify the office space for the company, so that in this case, when it gets that certificate, it can be able to immediately commence business. He might enter into agreements, maybe in this case with what? A land. Just in this case, having to look for office space. He might actually end up having to source for furniture. Those contracts, basically, in this case, will likely be done by what? By the promoter to support, enable the formation of the company. So we call them, in this case, what? Pre-incorporation contracts. So part of the duty is to enter into any pre-incorporation contract. So far as that kind of a contract, it is necessary to enable this company having to come into existence. These are part of the duties of, in this case, a person we call what? A promoter. And of course, you can be able to see, I have super highlighted. This is a danger Musumeno area in the exam. It can easily be tested. It is one of the most commonest in the exam. It is one of the most commonest in the exam, the duties of a promoter. Or what role does, in this case, a promoter end up having to, in this case, do what? Undertake during the formation of what? Of the company. During the formation of the company, the duties of a promoter. The duties of a promoter. So this promoter, when he's having to undertake all these procedures, he has to, in this case, act with what we call utmost good faith. What do you mean by utmost good faith? He has to act at all times in the best interests of the company. For example, when you talk about this contract having to be entered into, there shouldn't be dubious contracts that, in this case, will end up having to make the company later on to be liable after formation. So he has, in this case, conduct himself or carry out himself with what we call utmost good faith. Any contracts is having to enter into before the company is formed. For example, in this case, if it happens, he has sold an asset to the company himself. He has sold an asset to the company. He has to do it with what we call utmost good faith. If it happens, he, for example, makes a profit on this kind of an asset, then it means he has to reveal that profit to the company eventually once it is actually formed. If he doesn't do so, he would have actually failed on his duty of utmost good faith. He would have actually made what we call a secret profit. If that is the case, then under the law, the company in this case will be at liberty, in this case, for example, to recoup that particular secret profit or recoup the purchase price of that kind of an asset, which in this case he secretly sold to the company without having to do what? Reveal the profits, which end up having now to be declared as having to be what? Secret profits. Secret profits. So a promoter is generally anyone who assumes a primary responsibility with regard to having to do what? Form the company. So according to this ruling here under Cruz versus Grant, a promoter was described as a person who undertakes to form a company with a given objective, set it going, and take all necessary steps to ensure that, in this case, this one has actually been accomplished for the company to come into existence. So the promoter, in this case, as I'm having to emphasize, he has to always act with what we call utmost good faith in the best interest of the company. In any case it happens, for example, he has sold an asset to the company, he has to reveal any profit that has actually been realized on that asset once the company has been formed. If he doesn't do so, then these kind of profits, if they actually realized later on, they can be taken to be secret profits, which in this case, the company will in this case be allowed, for example, to recoup or take over those secret profits. A promoter is accountable to the company for all the money secretly received or any profit made directly or indirectly out of the promotion activities, whether it is made at the expense of the company or not, unless the company consents to it after all full disclosure is actually made, then this kind of, in this case, profits can actually be taken to be what we're calling secret profits. As a promoter who makes a secret profit without having to reveal, then in this case, he'll end up having to be completely compelled to surrender those kind of profits to the company. He would have failed on what we call the duty of utmost good faith. In fact, in this case, you can be able to see put here, we call it the duty. So in this case, I've already been able to indicate here. failed on the duty of acting with what utmost good faith in the best interest of what of the company. And it is explained by this case law here. Gluckstein versus Benz. What happened? The promoters of the company bought a property of 140,000. It's supposed to be pounds. Supposed to be pounds there. 140,000 pounds. 140,000 pounds from a company in financial difficulties. They made a profit of 40,000 pounds. A profit of 40,000 pounds on the purchase price. They then sold it to the company at an additional profit of, in this case, what, 20,000 pounds. They made a profit when they were selling this asset to the company. They disclosed their profit of 40,000 pounds, the initial profit of the 40,000 pounds. But in this case, they ended up not having to disclose the profit of, in this case, 20,000 pounds. And therefore, this one was actually taken to be a secret profit. They never disclosed this 20,000 pounds. So when the company went into liquidation, a few years later, the court held that the promoters were liable to hand over the 20,000 pounds, which was in this case a secret profit. The 20,000 pounds, which in this case was actually a secret profit, which was actually in this case a secret profit. So they actually failed to act with utmost good faith, or they failed on their duty of acting with utmost good faith, because they made a profit on the sale of the asset to the company during promotion, but they never revealed it. So overall, in this case, this actually safeguards the company to ensure that in this case, at all times, the promoters should be able to act with what we call utmost good faith, or in the best interest of the company, with contracts having to be entered into for the benefit of the company. So that in this case, way later on, the company shouldn't actually end up having to be liable. In this case, contracts which in this case are not for the best interest of the company. If it happens that in this case, the promoter has actually, for example, made a secret profit, then these are part of the remedies that in this case the company can be able to have. Number one, what they can be able to do is to recover those secret profits that were actually made by the promoter on the formation of the company. So they can recover the secret profit. For example, this 20,000 can be recovered. Alternatively, if in this case, the asset is still actually in existence of the company, they can recover the initial purchase price. This one, so the initial purchase price, which I think it is actually 140,000 pounds. So they can recover it. So they can give back the asset back to the promoter. They tell him, bring the 140,000 pounds. Or if in this case it happens, the asset has already been sold to a third party, they can recover those secret profits. Or in this case, alternative, they can also be able to recover any damages or loss that were suffered by the company during that contract where the promoter sold the asset to the company. So there are three remedies. So where the promoter has made a profit through the sale of a private property to the company may rescind or avoid the contract and recover the purchase price. Majorly in this case is, for example, if the asset is still in existence within the company, but maybe this asset has already been sold to a third party. So where the rights under the property have been acquired by a third party, that asset that was actually sold by the promoter to the company doesn't still actually hold it. They have sold to another person. So it is not within their means. They cannot return to recover the purchase price. In that case, they just only recover the secret profit. They just recover only the secret profit. Then the third remedy here, if it happens that in this case, the company suffered any damages or losses during this particular process where the promoter was having to sell the asset to the company, then the company is actually in this case at liberty to sue for the recovery of, in this case, damages or losses from the promoter. So where the fraud is proved, damages may be recovered from the promoter, and if he's a director, he may be liable for having been able to misapply the funds of the company. So that in this case, for example, if the promoter ends up having to breach the duty of utmost good faith, or having to act in the best interest of the company. Those are the remedies that in this case would end up having to arise. Then you have in this case remuneration of a promoter. So when you talk about to remunerate, in this case, it's to compensate the promoter for the work he has actually been able to do. So ideally, under the law, there's not actually in this case any requirement that the promoter must be paid for the services he provides with regard to having to form the company, because you can be able to see he plays a key role. Undertaking all these duties to ensure the company comes into existence.
So there's no, like in this case, legally, how the promoter can be able to, can actually be in this case, be remunerated or be compensated. But ideally, companies can actually be able to now remunerate the promoter in a number of ways. Voluntarily, the company can be able to remunerate a promoter in a number of ways. So number one way, in this case, he can actually be remunerated or compensated for the work he has been able to do. They can actually be able to allow him, of course, to be able to sell a property or an asset to the company. But there's a rider to this, which you've already been able to indicate. He must be able to disclose any profit made on the sale of such kind of assets. Failure to which they will be taken to be secret profits, and therefore it means he would have actually failed on his duty of utmost good faith or having to act for the best interest of the company. So he can be allowed to sell assets and, of course, get something. He can, in this case, be given a commission on shares sold. This is where we're having to talk about it is a public company, and therefore he prepares a prospectus to facilitate the sale of the shares on the formation of the company. So he can be given a commission on the number of shares that in this case have actually been sold. He can be allotted fully paid shares, just free shares. Those are, like in this case, free shares, or debentures in the company. He can be given free shares and be told you've done a lot of work. So ideally, we're going to give you some shares, you become a shareholder in this company. He can be allowed to buy shares at a very fair price or a discounted price, which is not in this case what? The market price of the shares. So he can be allowed in this case to get some more or extra shares in the company at a very discounted or very fair price compared to what others are having to purchase the shares for. He can be appointed amongst the very, very first directors of the company and serve there as what? As a director. He can enter into a contract with another company, or in this case, he can actually enter into contracts to enable the formation of the company. So he can enter into the contract with the company after formation, so that in this case, he can agree he be compensated or be remunerated for the work he's been able to do as what? As a promoter. So he can now, in this case, after the company has been formed, formally he tells them, I've done a lot of work, guys. So ideally, I must be able to get something. So they'll now, in this case, enter into a contract formally and, of course, say, for the work you did, we're going to pay you 200,000. So you'll be able to get that money. So you can formally enter into an agreement with the company after formation to be compensated or be remunerated for the work he did as what? As the promoter of the company. So those are, in this case, just some of the ways in this case as to how the promoter of the company can be remunerated or be compensated for the work he has actually been able to do as a promoter of the company, as a promoter of the company. So that also is actually very common in the exam. They like that one. They like this one. So remuneration or compensation of, in this case, what? The promoter. The promoter. So we can, in this case, look at one or two questions. Just one or two questions. Then we see, we close up with this class. We can be able to look at one or two questions. We see whether we can be able to close up with this class. I want someone to read for us this one. So, what are the qualifications of a promoter? There are no qualifications. There are no qualifications. Can these contracts be enforced against the company? But they can be. So we look at it in our next class. So we call them rules governing pre-incorporation contracts. They can, but not always. They likely basically be on the promoter, but we look at it. So let me not discuss it for now. So we look at it in the next class. So rules governing pre-incorporation contracts. So it means you'll have to be there in the next class. I'll be able to explain that. So I want us to look at this question here. This particular question here. Question number 1A. Who's going to read for us? People need to participate here. Where are the promoters found? Yourself, you can be a promoter, Elizabeth. Yourself, you can be a promoter. So long as you do those duties I've indicated there, you are the promoter. No major qualification. So I can see John Ogueo was the first one. So then we have Alice. Maybe, John, you can read for us this first one. Then Alice will read for us the second one. So John Ogueo. So we can have John Ogueo. So let me unmute you. There are no qualifications. So long as you, for example, if I undertake all that process and ensure that a company has been formed, I become the promoter. So there's no like major qualification that so long as any person who undertakes that process, he's given that name under the law as a promoter. So John Ogweo. Yes, John Ogweo. You can unmute yourself.
Yeah, thank you very much, Malim.
Yes.
Question 1, part A. Your friend intends to start running a medium-sized enterprise as a sole proprietor in his local town. He has come to you for advice on the possible challenges he might encounter as a result of operating his business. The required, advise your friend on 4 possible challenges. Your friend intends to start running a medium-sized enterprise as a sole proprietor in his local town. He has come to you for advice on the possible challenges he might encounter as a result of operating his business. The required, advise your friend on 4 possible challenges about the form of business he intends to operate.
Thank you so much,
Marks.
John. Thank you so much, John, for having read to us so well. So, of course, I told you they can ask you disadvantages, they can ask you advantages, they can ask you differences between a sole proprietor or what? A company. So, for this one, they're asking what? Disadvantages. So, from those features we mentioned, you can be able to get a disadvantage. For example, what could be the disadvantages or challenges? He or she will end up having to bear all what? The losses for the business. So he won't end up having to, in this case, for example, share. He'll be the one having to suffer all the losses. Limited resources. So this point of ours, limited resources in terms of capital. That is a challenge he'll have. He won't have like a wide base of capital. He'll just, in this case, maybe depend upon a lot on maybe savings, or maybe in this case, a few borrowings here and there. Unlimited liability is part of the challenge. In any case, the business has a liability, he'll end up having to bear it even himself, and personal assets can be attached. Very brilliant there. That is a point you can be able to mention. Lack of expertise in having to manage the business. So he might end up having to lack expertise unless he ends up having to, for example, in this case, learn more about business management, bookkeeping. He has to improve on his skills. So he might suffer from, in this case, what? Lack of skills to be able to manage what? The business. That is a point you can be able to, in this case, bring up. Kevin Kabisa, that is very brilliant. No perpetual growth, or maybe in this case, what? Succession. So it means, even in the case, in this case, the owner is not there, the business is likely to come to an end. So he has to always to be there. He has to always, in this case, to be there. So, too much work. So with that, you can be able to relate in this case what? He manages the business by himself, and therefore, in this case, it means the death of the owner can actually end up having to lead to what? The end of the life of the business. End of the life of the business. Yeah, so those are some of the points. So this one was easy. It was not that difficult. It was easy for them. So these people enjoyed. Those who started for April 2025, they enjoyed. So let me see whether we have another question here. For it was it Alice. Alice can be able to read for us. Let me see. So these are the ones we haven't covered. It seems there's no any other question from what we've already covered. So let me go to December. Let me see whether we have something from December 2023. We must be having something from December 2023 or 2024. 2024, December 2024. Let me see December 2024. If you have a question there. So let's look at this one. Let's look at this one. There's this one here, question number 1B. So our friend, there was one of our friend who wanted to read. Was it Alice or who was it? It was Alice. So this one we can give Alice. Alice, you can read for us this one. Yes, Alice. Question number 1B.
Yeah, thank you. Explain two differences between a holding company and a subsidiary company.
Yes, a holding company and a subsidiary company. So of course, this one we learned about it under the types or classifications of companies. So when you talk about a holding company, so one of the difference in this case, we can be able to indicate about a holding company, and of course, in this case, a subsidiary. So we can be able to say that a holding company is a company that has an ownership stake or a shareholding in another company. A holding company is a company that has a shareholding or an ownership stake in another company. So it has a shareholding or an ownership stake in another company. While on the other hand, a subsidiary is a company which its shares have actually been owned by another company in the majority. Is a company which its shares have actually been owned by another company in the majority. What I mean by in the majority, it is actually more than 50%. 50%. So for a holding company, simply basically in this case is a company that has a shareholding or an ownership of shares in another company. So they can be able to own 10%, 20%, 30%. While in this case, on the other hand, a subsidiary is simply a company which its shares have actually been owned by another company in the majority. In the majority simply in this case means it is actually more than 50%. So of course you learn more about this one in financial reporting. Oh, there's a very nice topic there that will be taught by your financial reporting teacher under what we call group accounts or what we call consolidated financial statements. Consolidated financial statements. So that's what we'll be able to learn there. That's what we'll actually end up having to learn there. That is the difference you can actually be able to mention as difference number one. Then number two difference, a holding company is able to control the affairs of the other company. So the holding company is able to control the affairs of the company in which it owns the shares. A holding company is able to control the affairs of another company which it owns what? The shares. So for example, in this case, if the holding company owns like 60%, like Luvaha, you remember the situation of Luvaha. Luvaha was actually having to control what? 60%, and the rest of you having to control 40%. So the holding company's voting rights will likely end up having to be more, and therefore in this case, it is able to control the affairs of that other company. So the holding company can be able to control the affairs or will fully be able to participate in decision-making of the affairs of the company in which it has an ownership stake. While a subsidiary company is actually on the receiving end, its affairs will end up having to be controlled by another company, which in this case ends up having to be the subsidiary company. So those are part of the difference you can be able to mention. So let me see what our friends are having to say here. A holding company prepares books of accounts for both the holding and the subsidiary company, while the subsidiary company cannot report the financial statement on its own. Yes, that is correct. So they do what we call consolidation. So the books will likely be consolidated by the parent company or the holding company. Then in this case, the subsidiary company, of course, it will be able to prepare independent books. Before they consolidate, they'll have to, first of all, have already been able to prepare what? Independent books. Then eventually, in this case, they can now be able to consolidate and actually end up having to put them together. And this one will likely be undertaken by the parent company. So that's also a difference you can actually be able to do what? Mention. You can be able to mention. So I can see James is having to say November 2020, question number 1A. So no problem. We can be able to see what that question is having to say. Let's see what that question is having to say. November 2020, question number 1A. November 2020, question number 1A. So still this one, Alice, you can be able to read for us. Alice, are you there? Yes, Alice. You can read for us. 1A.
Yes, question number 1. In relation to formation of companies, explain 4 common law duties of a promoter.
Roman 2.
Discuss 3 rules that govern pre-incorporation contracts.
Yes, thank you so much. So the common law duties, basically in this case, the duties we've already been able to look at in our notes there, they are borrowed from the common law. Like in this case, proposal of the name of the company, proposal of the registered office of the company, proposal of the objectives of the company, coming up with the memorandum and the articles. So when you mention those ones, you'll be able to get your marks. Huh? They are borrowed from the common law. The common law is the traditional English law, which is a source of law. You must have already been able to learn about this one in law and governance. Did you do law and governance? You learned about sources of law, where you learned about, in this case, what? The common law. You learned about acts of parliament. You learned about Islamic law. You learned about what else? There are so many of them. So from the common law, those duties are actually borrowed from the common law. So they are those ones we just been able to look at in class. So the ones we just been able to look at. Then discuss the rules governing pre-incorporation contracts. This is now what we'll be able to look at in our next discussion. But of course, they are here in your notes. Rules governing pre-incorporation contracts. They are here. You can be able to see I've already been able to highlight. This one I've highlighted. So danger to men of that one. Also, I've highlighted rules governing pre-incorporation contracts. So we'll discuss them in our next class, which in this case will happen next Monday. Will it actually be next Monday? Next Monday. It will happen next Monday. So what I can be able to indicate to, there's a proposal that our today's class, we might end up having to move it to Saturday, 2 p.m. But that might end up having to commence next week. So I'll give you a clear communication next week, Monday. So it might move to, I think it'll move to, I think, Saturday, 2 p.m. So, but I'll be able to communicate on Monday. I'll communicate on Monday. Yes, if it moves, it might move permanently. You are saying very tricky. So I'll communicate next week, Monday. So I'll communicate next week, Monday. I'll communicate next week, Monday. So I've seen your feedback here. So I'll communicate next week, Monday. So otherwise, see you next week on Monday. So have a good night. Have a good night. Have a good night. See you on Monday.